If you watched our first video, you know that to file for bankruptcy, you'll need to gather all of the necessary information and documents the court requires. If you also have student loans, it's important to know what you'll need to show if you want to get those student loans discharged in your bankruptcy case. Let's take a look at what that means. Generally dischargeable debts. Most consumer debts, such as credit card debts, store cards, and medical bills, are generally dischargeable in a bankruptcy. That means that, if the bankruptcy is successful, you do not have to pay those debts. However, the bankruptcy law states that student loans are not dischargeable unless you can prove that paying back those loans creates an undue hardship for you and your dependents. Discharging student loans requires a separate legal proceeding in your bankruptcy filing. It is strongly recommended that you speak with an experienced bankruptcy attorney about whether bankruptcy is right for you. Undue hardship overview. So how do you prove you have an undue hardship? Depending on the state you live in, the bankruptcy court may use either a three-part test referred to as the Brunner test, or a similar totality of the circumstances test, to determine if you have an undue hardship. Most states, including New York, use the three-part Brunner analysis, which looks at your current, future, and past financial situations. You must prove all three parts of the Brunner test to get a discharge of your student loans. Let's take a look at what that means. Undue hardship. Current inability to pay. The court will first look at your current inability to pay back your student loans while maintaining a minimal standard of living. The court will review all of your current income and living expenses, such as rent, food, and utilities, to see if you are able to pay back all these necessary expenses as well as your student loans. The court will want to know why you can't cut back on your monthly living expenses in order to pay back these loans. Undue hardship. Future inability to pay. However, it is not enough to show that you can't pay now. You will also need to show that there are additional circumstances, such as illness or disability, that are likely to last for a significant portion of the repayment period of your student loan. You must show that these additional circumstances will prevent you from making payments in the future. Here, the bankruptcy court will want to know why your current financial hardship is not just a temporary setback. Undue hardship. Past good faith repayment efforts. Finally, you will need to show that in the past you've made good faith efforts to repay your student loans. Here, the court will review your past repayments on the loans, as well as any efforts you've made to work with a lender to try to keep your loans up to date, such as by requesting an income-driven repayment plan. Additional factors. It is important to note that the bankruptcy court may take other factors into consideration as well, such as whether you qualify for an alternate repayment plan for any of your loans. Additionally, if you have some federal loans and some private loans, each type of loan will be subject to its own analysis. Student loan discharge in bankruptcy is determined on a case-by-case basis, and the court's analysis will be based on your specific circumstances. Bankruptcy discharge. Full or partial discharge. If you're able to meet the requirements for all parts of the undue hardship analysis, that is, 1. Current inability to pay, 2. Future inability to pay, and 3. Past repayment efforts, then the bankruptcy court may grant you a full discharge of all of your student loan debt. This means that you will not have to pay back any of those loans in the future. But even if you cannot meet the undue hardship criteria in full, it's possible that the bankruptcy court could grant you a partial discharge of your student loan debts, reducing the overall amount that you owe. Additionally, the court may lower your monthly repayment or cut back on the number of payments you must make. So even if you cannot get a full discharge of all of your student loan debts, bankruptcy may still be able to provide you with some relief from your student loans. For many people, bankruptcy can offer the enormous relief of a financial fresh start. If you can sufficiently prove that the repayment of your student loans creates an undue hardship, you may be able to discharge your student loans as part of a bankruptcy filing. It can be a difficult process, but for some people, the difficult task is worth it to be free of student loan debt. If you're struggling to repay your debts, bankruptcy is a legal and proper way to take control of your financial situation in order to emerge with a fresh financial start. But because filing a bankruptcy is a complex process, you should speak with an experienced bankruptcy lawyer about your options. We hope these videos have been helpful. For additional resources and information regarding student loans and the bankruptcy process, please visit the following resources. The City Bar Justice Center would like to thank the American College of Bankruptcy and the American College of Bankruptcy Foundation for their generous support.